Welcome everyone to the House Committee on Judiciary and Hawaiian Affairs. My name is David Tarnas. I am the chair of the committee, and to my right is Representative Greg Takayama, Vice Chair, and we're grateful to have Representative Mizuno and Representative Souza here on our committee. The others will join us as soon as they can. It's February 16th, 2 p.m. here in Conference Room 325 at the State Capitol, and we're also running this hearing by video conference as well. For those who are testifying, I would request that you keep your testimony to a couple of minutes, and I'll ask you to summarize at that point, just to make sure everyone has the opportunity to testify. If you're testifying via remote testimony on Zoom, please keep yourself muted and your video off until we call you to testify, and then turn your video on, unmute yourself, provide your testimony, and when your testimony is complete, mute yourself again and turn off your camera. If you have technical issues, you can use the Zoom chat function to communicate with the technical staff, and they'll do their best to take care of you. If you're disconnected unexpectedly, just try to rejoin, and I'll try to allow you to give your testimony when you come back. If for some reason we have to reschedule the hearing because the electricity goes off or whatever, don't worry, we will reschedule and post the hearing notice so that you can be notified. If you're testifying on Zoom, please avoid any trademarked or copyrighted image. And for all testifiers here in person and on Zoom, please refrain from profanity or uncivil behavior. That's okay to disagree, but let's not be disagreeable. We're all in this together, so we're trying to work as allies. Thank you very much. Let's go ahead and get started. First up, we have House Bill 340 relating to Brother Joseph Dutton Day. First up, we have testimony from Keith Regan, Department of Accounting and General Services. Welcome. The floor is yours. Please proceed.
Thank you, Chair, Vice Chair, members of the committee. I thank you for this opportunity. Representing Comptroller Regan, I am Dr. Adam Jansen. I have the privilege of serving as State Archivist and Administrator of the Public Archives. DAG stands on its testimony in support. And as an archivist, I applaud this opportunity to educate the people of Hawaii and to breathe life back into these voices that have been silenced because of the ravages of time. I welcome the opportunity to address any questions or concerns you may have.
Well, tell us about these letters. It's in the testimony.
It's
cool.
Absolutely incredible.
Totally cool.
Because we have 14,000 boxes, I didn't even realize we had these letters, but we have over 100 letters from Brother Dutton back and forth, asking for things, describing his experiences, what's going on. We have photographs, we have his daily journals, and it's an opportunity for us to digitize these and then share them with all of the educational institutions to try and teach them about Brother Dutton and Father Damien, whose letters we also have, and Kalopapa, whose records we keep. And so if it's not obvious, I'm really excited about this opportunity. So, thank you very much.
Thank you very much. I share your excitement.
Thank you.
Those historical records are treasures, really, and I appreciate your diligence in taking good care of them and digitizing them so they'll be readily available.
It's our honor. Thank you.
All right, thank you. Thank you, Doctor. Next, we have testimony and support from Patrick Bolin with the Joseph Dutton Guild. Testimony and support from Victor Ramos, Dara Yatsushiro, and H. Davis, and Lisa Smith. Is there anyone else wishing to testify on this measure, HB 340? If not, questions, members? Seeing none, we'll move on. Thanks very much. And I want to note for members that we got a revised testimony from the Joseph Dutton Guild, which modifies their earlier testimonies in a substantive way, and we can discuss it in decision making. Thank you. Okay, next, moving on, House Bill 105 relating to license plates. This is very interesting. It requires license plates to include Okina in the word Hawaii, and it authorizes the use of all uppercase letters, all lowercase letters, or initial capital letters in the word Hawaii and Aloha State on license plates. That way we can spell the name of the state properly. So this is an important measure, HB 105. First up, we have testimony and support from Kimberly Hashiro, City and County of Honolulu Department of Customer Services. Please proceed.
Hi, good afternoon, Chair, Vice Chair, and committee members. Deputy Director Derek Mayashiro testifying for my director, Kim Hashiro. We'd like to rest on our written testimony and support, but we are here for any questions that the committee may have.
Thank you very much, Deputy Director. Next, we have testimony and support from Dana Kiabe and Dara Yatsushiro. Is there anyone else wishing to testify on HB 105? Seeing none? Questions, members? Seeing none? We'll move on. Thank you. HB 739, relating to motor vehicle safety inspections. It requires the Department of Transportation to amend its administrative rules to repeal any provisions requiring the furnishing of evidence of registration as a condition precedent to receiving a certificate of inspection. 739, first up, we have testimony and support from the Department of Transportation. Please refer to their written testimony and support. Next, we have testimony and support from the City and County of Honolulu Department of Customer Services. Mr. Miyashiro, do you want to testify on this measure too? Please proceed.
Thank you, Chair. Thank you, Chair. We'll rest on our written testimony and support.
Okay, thank you. And could you briefly summarize your recommended amendments?
Yes, for this particular bill, we're asking that the bill be limited to only those situations where both the license, the registration and the safety check are both expired, and for priority to be given to the registration itself, that the registration be done first and then the safety check.
Okay, thank you for that explanation. Next, we have testimony and support from Andrew Crosslin, Dana Kiabe, and Shannon Rudolph. Is there anyone else wishing to testify on House Bill 739? Seeing none, questions, members? Nope. Okay, thank you. All right, we'll move on to the next bill. House Bill 365, relating to special management areas, expands exclusions from the definition of development as it applies to special management areas to reduce the need for special management area permits for certain activities that are enumerated in the bill. First up, we have testimony and support from the Office of Planning and Sustainable Development.
Hi, good afternoon, Chair.
Please come on up to the podium so everybody can hear you.
Thank you. So, good afternoon, Chair, Vice Chair, and committee members. The Office Planning and Sustainable Development support this bill and stand on the written testimony.
In support.
Yes.
Okay, thank you very much.
Thank you.
Next, we have testimony and support from Alice Lee, Council Chair, County of Maui. Testimony also from Curtis Lum and the Hawaii State Association of Counties. That's all the testimony we received on this measure. Is there anyone else here wishing to testify on House Bill 365? If not, questions, members? Seeing none, we'll move on. Thank you very much. House Bill 792, relating to minors. It grants a circuit court, when sentencing a minor for criminal offense, the discretion to impose a sentence that includes a period of incarceration that is as much as 50% shorter than any mandatory minimum, and in certain cases, decline to impose a mandatory enhanced sentence. HB 792, we have testimony from Darcia Forrester, Office of the Public Defender. Welcome, thanks for being here. The floor is yours. Please proceed.
Aloha again. My name is Darcia Forrester. I'm the Juvenile Division Supervisor at the Office of the Public Defender, which is why I've come today. So the Office of the Public Defender supports the intent of House Bill number 792 with some recommended revisions. Minors should be treated differently from adults based on their brain development, impulse and behavioral control, vulnerability to negative influences and pressures, and their limited control over their home settings and their living conditions, which sometimes can be traumatic and abusive. This is especially important for any minor who has been waived into the adult court system. However, we do have some recommended revisions as detailed in our written testimony to ensure that this bill covers all persons who committed an offense prior to reaching the age of 18. We do recommend that the term minor, in quotes, be replaced with the term, in quotes, minor or adult convicted of a felony offense that was committed prior to reaching the age of majority. Otherwise, this bill would not apply to persons who committed the crime prior to reaching the age of 18, but then were subsequently convicted as an adult and wouldn't have the benefit of this law. So I'm happy to answer questions later if you have any. Thank you.
Thank you very much. Appreciate that. Next, we have testimony in support from Opportunity Youth Action Hawaii. Testimony in support from Kat Brady, Community Alliance on Prisons. Testimony in support from Patricia McManaman, and testimony in opposition from Ruth Love. Is there anyone else wishing to testify on House Bill 792? Seeing none, questions, members? Yes, Representative Souza, please proceed.
Oh, for the public defender, thank you. Thank you so much for being here. I just had a question. Do you think that minors were getting like a disproportionate sentencing for across the board? What were you guys seeing that would warrant this?
To be perfectly frank, waivers into adult court are rare. They do happen, but they don't happen often. The family courts really treat a waiver hearing very seriously. They delve into the whole family life of a juvenile before making that decision. I think that our position is we support the bill because even if one minor was impacted negatively, then we would be concerned about that. But I can say that right now it's actually quite rare. And I think that's also the result of there being more services available for youth in the family court system than before. So we just have a little more options when we have youth coming in for felony offenses that may qualify for a waiver. I hope that answers
No, great,
your question.
thank you. Thank you for explaining.
Thank you very much. I was just told that Mr. James Dold has, who wanted to give testimony, has joined us on Zoom. Mr. Dold, if you're there, please proceed and provide your testimony to us on HB 792.
Absolutely. Thank you so much, Mr. Chairman and members of the committee. Thank you for allowing us the opportunity to testify. James Dold on behalf of Human Rights for Kids. The reason this bill is so important is because, under international human rights standards, children really are supposed to be treated differently in the criminal justice system. Specifically, Articles 37 and 40 of the CRC specify that children are to be treated under different standards, sentenced by different standards than we use for adults. And this is something in the criminal law that we've begun to recognize over time. The U.S. Supreme Court, in a series of cases, actually has ruled that certain types of punishment are simply inappropriate for children. For example, the use of life without parole has been struck down for non-homicide related offenses, as well as for homicide related offenses under the Supreme Court's jurisprudence in Miller v. Alabama and Montgomery v. Louisiana. Those cases have actually been extended in some jurisdictions. So, for example, in 2020, the Washington State Supreme Court ruled that sentencing children by mandatory minimum sentences without first considering the mitigating factors of youth that the court discussed in Miller was actually a violation of the Eighth Amendment's prohibition on cruel and unusual punishment. So they actually relied on the federal Constitution's prohibition against cruel and unusual punishment to strike down mandatory minimums in Washington state. The Iowa State Supreme Court similarly held under its state constitution that mandatory minimums were also a violation of the Eighth Amendment. And a simple reason for that being that, everything that we know about youth, their brains aren't fully developed, they're more impetuous, they're more likely to engage in risky behavior. This is something, the Supreme Court has noted every parent and grandparent knows, but really brain science is able to show us really for the first time.
Thank you. Could, Mr. Dold, if you could summarize, that'd be great. I appreciate the information.
Absolutely, Mr. Chairman. So in summary, this is a critical provision to make sure that we're protecting the human rights of kids in the justice system. For context, Maryland last year, or rather in 2020, passed this exact same law. They got rid of all mandatory minimums for children, allowing judges to have complete discretion. Virginia did it the year before. with both Democratic and Republican support. Nevada has a similar provision
Thank you.
as well as Montana. So we would
Thank
urge
you.
the committee's favorable report. Thank you.
Thank you very much. And just for those who don't know, and I'm one of them, Mr. Dole referred to the CRC, that's the Convention on the Rights of the Child. We're all learning new things here, and so that was his code, CRC. Mr. James Dole with Human Rights for Kids. And I want to also provide the opportunity for Kat Brady to provide her testimony since she also just arrived. Kat Brady testifying from the Community Alliance on Prisons on HB 792. Please proceed.
We are in, Community Alliance on Prisons is in strong support of this. A lot of what I was going to say has already been said, but we know their brains are not developed, they're impetuous, but they're so amenable to treatment. So I agree with everything that's been said.
Thank you. I appreciate you being here. Anyone else wishing to testify on HB 792? Other questions, members? Representative Ganadin, please proceed.
I'm Ms. Forrester with the Office of Public Defender. Got it.
Hello.
Hey, good afternoon. I didn't see testimony from the Office of the Attorney General. I'm wondering if we're going to have to amend other sections of the criminal code as a result of this, because it seems like this implicates a variety of prospective felonies under the criminal code. So it's like, are we going to have to add on to this with an HD2 a variety of different charges or misdemeanors?
I'll be honest, I don't know. I can't answer your question. I think you'd have to look at the different statutes that it implicates and figure out if revisions would be required, but I would have to do a little bit of research. Our biggest concern, quite frankly, was that the term minor just wasn't broad enough and that it could potentially exclude from the benefit of this someone who was 17 at the time of the offense but turns 18 by the time they get sentenced in adult court, or even 19, because cases take so long to process. We just wouldn't want a respondent. A respondent is someone whose case started when they were a minor but then they turned 18 and their case is still active. We wouldn't want a respondent to not have the benefit of this.
Understood. Thank you. Representative Gannon, please continue.
I'm going to reference another bill that we're proposing to expand the judiciary's ability to do cultural courts.
Yes.
To do.
I'm familiar.
Yeah, so of
Yes.
course. And thank you so much for your support on that, to be influenced by the work of essentially other indigenous nations and working with the overrepresentation of Pacific Islanders in the justice system. Will a sentencing court, if they're out in the community, be able to modify their sentence accordingly if we pass HB 792?
I don't think it would apply at all because this bill specifically refers to youth who respondents who are waived into adult court. So if we were my understanding is that the Pacific Cultural Court was for juveniles who would still be monitored in the juvenile system. But once you're waived, the family court gives up jurisdiction, their original jurisdiction, and everything goes over to circuit court and you are treated as if you were an adult. So you wouldn't have the benefit of a cultural court under my understanding of what the proposal is for the creation of a cultural court. That would solely be for juveniles who were in juvenile court, still in the family courts. That's my answer.
Okay, thanks. Oh, one more question. Yes, please, go ahead.
Is this going to implicate any prospective federal charges? Because I know sometimes,
Well-
county prosecutors might basically allow a defendant to be charged under the federal court, and vice versa. Is this are we going to run into some headaches with the federal jurisdiction?
The way I read this, I think the only impact it would have is if a federal conviction was used as the basis to justify a mandatory minimum or some sort of sentencing enhancement. That's the only way I think that they could be connected, because sometimes you can refer to federal convictions for enhanced sentencing as an adult.
Got it.
Great. Thank you very much, Representative. Any other questions? Representative Mizuno.
Thank you, Chair Tarners. James Dode, please. Yeah, Mr. Dode. Okay, while we're waiting for Mr. Dode, if he's trying to get on, could I have the public defenders come back up?
Getting a lot of exercise.
Yes, yes. I've looked at testimony from Public Defender's Office, and I think you cited a United States Supreme Court that talked about the brain development of youth under the age of 18.
Yes.
And is that part of the reason to support a measure like this?
Yes, I mean, we strongly feel that young people, even people who might be 18 or 19, their brains are still developing. There's the science supports that children, youth, and young persons, even up to maybe the age of 25, are still experiencing growth, brain development, cell development, maturity. And so we just really feel that, especially for children where crimes have been committed as a juvenile, if they are sent into adult court, they should not necessarily be treated like they were 35 years old and fully period.
Yeah.
And period.
Right, and just a clarification, Mr. Chair, if I may. So I think the friendly amendment you had was to amend the bill to have that minor, who was maybe 16 or 17 at the time, but later on they turn age of majority 18, then they're charged with the felony, and then they're charged as an adult. Is that correct?
No. So my reading of the bill
Right.
is,
Oh, but that's the amendment you want, though, right?
so I think I need to clarify. We're not talking, okay. So when you're waived into adult court, it's for crimes that were committed while you were still a juvenile. But some of our young people are 17. So it could be that they're waived into adult court. They might still be 17, but turn 18 before they're getting sentenced. Those are called respondents. So it's not that so we want to make sure that anyone who is being sentenced for an offense that was committed while they were still under the age of 18 has the benefit of the first part of the bill.
Right, protections.
And they not be excluded just because they were 18, because it took a long time for their case to finally get to the sentencing phase.
So what you're saying is if I was 17 and I committed the crime, but later on I turned 18 and they charged me as an adult, you're saying the bill should protect me when I was 17 years old because that was the time I committed the crime?
Correct, yes.
Okay.
Yes.
No, thanks for the clarification. Thank you, Chair.
Thank you.
Appreciate it.
Thank you very much. Any other questions, members? If not, let's move on. House Bill 781, relating to children, requires that when an officer has custody of a child under the age of 18 for an alleged violation of a law, the child shall have contact with legal counsel and, to the extent practicable, a parent or legal guardian before the child waives any constitutional rights and before any custodial interrogation. First up, we have testimony in support from Darcia Forrester. Thanks for being here. Appreciate
Aloha
it.
again.
Aloha. Please proceed.
Thank you. The Office of the Public Defender supports House Bill number 781 HD1 in part, but we do have an issue with one of the parts in the bill. So we are supported in part and oppose it in part. So I'll just provide a short summary for the public.
Yes, thank you.
For the first section regarding access to legal counsel, we strongly support the requirement that any child under the age of 18 have access to legal counsel before waiving any constitutionally protected right and before any custodial interrogation. Children require special and additional legal protections and assistance to help them understand, process and participate in any kind of custodial interrogation where their constitutional rights are impacted. Next, I'll go to the next section. So regarding admissibility of statements, the Office of the Public Defender does have concerns with the provision set forth under Section 2, subsection D of this measure. First, this provision will not excuse any officer from interrogating a child without first advising the child of his or her Miranda rights, including the right to remain silent and right to counsel. Second, any interrogation regarding, quote, information necessary to protect life or property from an imminent threat that takes place between a police officer and a child will likely be part of a much fuller interrogation on other matters, including any involvement of the alleged crime, and may be misinterpreted by law enforcement as a means of believing that certain conversations are sanctioned under that statement when they are in fact constitutionally improper. In other words, a detective may unwittingly believe they are allowed to interrogate a child because of this provision and that their case will not ultimately be jeopardized when in fact the statement may not meet constitutional muster and still be suppressed based on established case law. The Hawaii Supreme Court has many cases that discuss custodial interrogation, and the rights that adults have, those rights children have as well. And so we had submitted in our written testimony a quote from the State v. Roman case,
Yes.
which sparked many other follow-up cases, but that quote kind of summarizes it. We don't think it's necessary to have Section 2 to provide constitutional protections, because those constitutional protections are already in place. So that it's not needed. They're already established.
Okay, so your recommendation is to actually delete Section D under Section 2, under there, that's on the bottom of page 3 of the bill, the paragraph starting D. So from there all the way to the next page, 1 and 2.
Correct.
So you're suggesting that we should amend it by removing that because it's not necessary and it might confuse matters.
Yes,
Okay.
we think it will cause confusion.
Okay.
Correct.
Okay,
Thank you.
thanks for that explanation. I appreciate that. And if we have further questions, we can come back after we go through the rest of the testimony. Okay, next we have testimony and support from Kat Brady, Community Alliance on Prisons.
Thank you again. We're in strong support of this. We think that kids are so susceptible to coercion after somebody is questioned for hours and hours. And we have many cases. The Central Park 5 is one that stands out in my mind, but many, many other cases where kids, after hours, say, okay, all right, what am I supposed to say? And they write a statement and say, just sign this. So we really believe legal counsel is necessary.
Thank you.
Thank you.
Thanks very much. Next we have testimony from James Dold. Mr. Dold, are you there? Please proceed.
I am, Mr. Chairman. Thank you so much for your time. Again, James Dole, representing Human Rights for Kids, and just want to thank Rep. Mizuno for bringing this as well as the previous bill. I forgot to thank him before. And we are testifying in strong support of this legislation as well. Ms. Brady mentioned the Central Park 5 case. When you look at the data from the National Registry of Exonerations that's run at the University of Michigan School of Law, what you see is that over 40% of children who were wrongly convicted falsely confess to their crime, and those are children under the age of 18. The lower you go, the higher that percentage is. So, and it's not really surprising for everything that we know about children. So, for example, when you look at children under the age of 16, nearly 60% of them falsely confessed to their crime when they were later exonerated. And then children under the age of 14, almost all of them falsely confessed. And this bill fundamentally, at its core, is really about making sure that children understand their constitutional rights before they waive them. And the only way to do that with any degree of certainty that the child is truly going to understand what their Miranda rights mean and the consequences of waiver is to make sure that they have a lawyer they can talk to who can explain it in a way where they can fully understand the situation. And again, Mr. Chairman, this goes back to the CRC that I referenced before, Articles 37, as well as the International Covenant on Civil and Political Rights, Articles 10 and 14, specify that the moment a child has their liberty taken from them, that they should be provided access to legal help and assistance, and that is absolutely critical. And then the last piece of this too, I just want to say, both as a parent, and that's why I have to apologize as well. I'm in the car. I just had to grab my kid from daycare. But for those of you who have children, just imagine your child being arrested and not knowing where they're at, right? I think all of us as parents would fundamentally want to be notified if our child has been arrested, and we'd want to make sure we have contact with them prior to them making a potentially life-altering decision, such as waiving their constitutional rights. Kids can't enter into contracts, they can't get married, they can't make a host of decisions, so why on earth would we allow them to do something as consequential as waiving their constitutional rights without talking to a lawyer and without talking to their parents first? So for those reasons, Mr. Chairman, we urge a favorable report of this bill. Thank you.
Thank you very much, and please say thank you to your young one in the car with you. Next, we have testimony and support from Michael Older, testimony and support from Dana Chiave and Patricia McManaman and Dara Carlin, and testimony in opposition from Ruth Love. Is there anyone else here wishing to testify on HB 781? If not, questions, members? Representative Ganadin.
It's Ms. Forrester with Office of the Public Defender. Thank you so much again for your work in doing this. As you know, I have some experience representing minors in court and working with the introducer, actually, in working with juveniles in our shared community. We saw an increase in interactions with the police and Pacific Islander youth during COVID. What kind of training do you think would be necessary for officers and for detectives in order to ensure that what we're trying to do, which is keep these kids out of entanglements with the police officers, doesn't even get to them? Like, how can we work with our partners in the county to ensure that they know that they shouldn't be asking these kids questions or taking them into custody without checking in with their parents or guardians first?
I think, personally, I think it would involve some policy changes at the county level with the individual police departments. I think that it would require them to adjust their policies when it comes to interrogation, specifically for anyone under the age of 18. So it might require them to implement some new rules, and perhaps some training for officers who've already been, graduated from the recruit school and who have been involved in on the street arrests, and perhaps training of active officers who are already in the field. I think that would be required. In terms of providing legal advice to minors, that would be our office providing training to our attorneys who do juvenile cases, and also providing access to those materials to court-appointed attorneys who are active on our juvenile list.
Yeah, like me. One more check.
Yes, please.
Do you think it would be helpful to add that into the bill as an HD1, a training component, and coordination between the judiciary, stakeholders, and police departments to ensure that we effectuate minors' rights?
I do think that would be helpful because it would get the attention of the different departments. And because they're county police departments, each county has their own set of policies. So it would encourage conversation so there's consistency statewide.
Thank you, Chair. That's my amendment suggested. Thank you.
Thank you. Thanks very much. Okay, any more questions, members?
I have a question, Chair.
Okay, go ahead.
Thank you. Mr. Dole, if you're there on Zoom. Yes, it's great to see you again. So you heard what the Public Defender's Office said, that the constitutional rights in Section 2 may be duplicative. Are you okay with the friendly amendment to delete that section?
Yeah, no, Mr. Chairman, we would be fine with it. I think that, the original language, when we put it in there, it was in an effort to assuage any concerns around, the public safety exception. I think to the public defender's point, that those aspects of the bill are well defined within the case law as well. So it's not necessary, I think, to have it in there. But again, it is within the case law, that narrow exception, and so we would be fine with removing it. And in our opinion, it would make the bill stronger. So yeah, we would be fine with it. I did want to note, one, I guess the only concern that I would sort of raise about the training component, we would say that is also a really important component of this. The only concern we would raise is whether or not that would have sort of any fiscal impact and might jeopardize the bill's passage, but we would agree as to the merit of that friendly amendment as well, that there needs to be training done to make sure that the different agencies understand what they're required to do under the law.
Right, and Chair, one last question, please.
One last question.
Okay, thank you very much. Mr. Dode, other states have passed similar legislation?
That is correct, Representative Mizuno. California enacted this law several years ago. They've implemented it quite effectively. Last year, Maryland, where I live, also passed this exact same legislation with strong bipartisan support. Other states, like more conservative states like North Dakota, also have this in place. And again, going back to the case law, in different states, their state Supreme Courts have developed what is known as the interested adult standard. So, for example, in Vermont, the Vermont Supreme Court ruled way back in the 1980s that a child's statements are inadmissible unless that child has had the opportunity to talk with their parent or legal guardian prior to waiving their constitutional rights. And so this is something that's been developed over the years through American jurisprudence, and having this codified in Hawaii state law would just be bringing Hawaii up to speed with California, with North Dakota, with Maryland. Oh, and I also forgot to mention Virginia as well. So there are a number of states that have already done this, and that is the direction that the country really is moving in. Utah passed this legislation last year. Also, I forgot to mention. So I think people are very much waking up to the reality that children need assistance when they're arrested, and that the best way to do that is to make sure they consult with legal counsel.
Thank you, Chair. Appreciate it.
Thank you very much. Any other questions, members? If not, we'll move on. Thanks very much to the testifiers. We have next up House Bill 618 relating to family, establishes an exemption from mediation in paternity proceedings where there are allegations of domestic abuse if the party alleging domestic abuse does not wish to participate. And it goes on, but that's the main thrust of the bill. HB 618. First up, we have support from the judiciary. Next, we have testimony and support from Angelina Mercado. Welcome. Come on up. Thanks for being here. Floor is yours. Please proceed.
Thank you for having me. Aloha Chair, Vice Chair, committee members. I'm Angelina Mercado, the Executive Director, Hawaii State Coalition Against Domestic Violence, and we are in strong support of this measure. What this bill would do is actually enable a survivor of domestic violence who may be engaged in a contested custody proceeding with their abusive partner the option, not the requirement, to engage in mediation instead of court litigation. This is really centered around survivor choice and making sure that we as a system, as a community, are not employing the same tactics of power and control that their abusers have on them. So the language in this measure actually already mirrors the language that's in HRS 580-441.5, battered spouses. And there's an exemption already from mediation and divorce proceedings. And really importantly, what that statute already includes are several protections for survivors should they choose to engage in mediation. So that's the option to have an attorney with them, to have an advocate with them, to work with the mediation center to make sure they're in separate rooms. So we're in strong support of this measure and appreciate the opportunity. Aloha.
Thank you. I appreciate you being here to testify. Next, we have testimony support from Hawaii Women's Coalition. Testimony from Keopu Raylitz. Testimony and support from Dana Kiave and Kyle Shelley, Carolyn Austin, Judith Armstrong, and Dara Carlin, and Barbara Service, Nikki Ann Yee, Dr. Faith Joyner. Is there anyone else here wishing to testify on HB 618? If not, questions, members? Nope, looks like we're all set. Thanks very much. Appreciate your testimony. Let's move on to the next measure. House Bill 1045. Relating to education, it requires a minor student's parent or legal guardian, rather than the student, to produce the required student records when transferring schools. Clarifies that emancipated minors may produce the required student records when transferring schools, and clarifies that the transfer process is the same whether a transfer is within the same complex area or to another complex area. And it exempts students eligible for assistance provided under the federal McKinney-Vento Homeless Assistance Act of 1987 for producing required student records when transferring schools. So for HB 1045, we have testimony and support from the Department of Education. Thank you very much for being here. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee. I'm Kara Tanimura, Interim Assistant Superintendent for the Office of Strategy, Innovation, and Performance, testifying on behalf of the Department of Education. The department stands on its written testimony in support of House Bill 1045, House Draft 1. Thank you for the opportunity to testify.
Thank you very much. Appreciate being here. Next, we have testimony and support from Dana Kiave. Is there anyone else here wishing to testify on HB 1045? If not, questions, members? Seeing none, we'll move on. Thanks very much to the testifiers. House Bill 1057, relating to interim administrative rules of the Department of Hawaiian Homelands. It allows Department of Hawaiian Homelands to issue interim rules that shall be exempt from the public notice, public hearing, and gubernatorial approval requirements of Chapter 91, HRS, Hawaii Revised Statutes, after beneficiary consultation is conducted by the Department of Hawaiian Homelands and upon approval of the Hawaiian Homes Commission. The interim rules shall be effective for not more than 18 months. So on this measure, HB 1057, we have testimony and support from the Department of Hawaiian Homelands. Thank you for being here. Please proceed.
Aloha Chair, Vice Chair, members of the committee, o Oriana Leal Ko'inoa, DHHL's Nahaza Government Relations Program Specialist. The department stands on its written testimony and support, and I'm available for questions. Mahalo.
Thank you very much. And next we have testimony in opposition from Ruth Love and Marion Kanani Kupuniai. Is there anyone else here wishing to testify on HB 1057? If not, questions, members? I have a question for the Department of Hawaiian Homelands.
Aloha Chair.
Aloha. Mrs. Kupuniai is my kupuna from my community. When I met with the Department of Hawaiian Homelands leadership a couple of weeks ago, we specifically brought up this bill, and Mrs. Kupuniai had already indicated her extreme displeasure with this bill. And her testimony continues to be in opposition. She feels like this would be infringing on the rights that should be subject to beneficiary consultation, despite what you say that you will be doing beneficiary consultation. She doesn't believe it, and she does not feel that this is merited. I had urged the department leadership to reach out to her to try to assuage her concerns. Either that must have been unsuccessful, considering the testimony we have here. Could you please, for Mrs. Kapuniai as well as everyone else who may feel the same way, explain from your perspective how this measure will assist Department of Hawaiian Homelands and how it will not reduce the requirements of beneficiary consultation as you have described it?
Mahalo for the question. Currently, the department initiates beneficiary consultation first. Those questions and comments are compiled in a report that is presented to the commission. The commission then has to approve the report and the proposal before the department can take any action. Afterwards, we then engage in a lengthy Chapter 91 process. This bill, if passed, would allow us to have interim rules for no longer than 18 months and then engage in the Chapter 91 process after to make permanent rules. And this is because we have received and listened to beneficiaries who have provided comments about the process being lengthy. I think the testifier is under the false impression that we would be eliminating beneficiary consultation entirely, and that is not true. That is still step one. Commission approval is still step two. If this bill were to pass, step three would have interim rules that we can abide by for no longer than 18 months, and then step four would be Chapter 91.
Okay. Okay. I had hoped that the department would have been able to convey that to Mrs. Kapuniai, and either the conversation never happened or it was unsuccessful. And I have to listen to my kupuna. I apologize. But it's just, she's adamant that this is going to reduce beneficiary consultation. So I think it sounds like the department's got more work to do in trying to convince the beneficiaries that this isn't going to reduce their opportunity for consultation.
I also have to listen to my kupuna, and the department remains with open ears to all of our beneficiaries, and we remain open to input on ways in which we can improve the beneficiary consultation process. Mahalo.
I appreciate your approach. Thank you very much. Any other questions, members? Representative Ganadin.
To the department.
Aloha, Representative Ganadin.
Is this exemption necessary for the department in the interim while you seek a new chair?
This legislative proposal was drafted long before the current status of the department, and even before the pandemic. But I will say, as a staff member who worked during the pandemic in office during the entire time, it allowed us the opportunity to review our processes and see ways in which we can amend them and alter them to better serve our beneficiaries. And that's what I hope that this bill will allow us to do.
One more quick one. Let's see. What kind of rules will you be thinking of amending here? Are these like big, broad rules regarding
Projects, development proposals, yes, all of the above.
Thank you.
Thank
Okay.
you.
Any other questions, members? If not, thank you very much. Mahalo. Okay, let's move on to the next measure. House Bill 542 relating to procurement allows bidders to clarify or correct immaterial or technical information required as part of a bid submission for up to 24 hours after the bid submission deadline, in addition to the time for correction or withdrawal of inadvertently erroneous bids before or after the award, as permitted by rules adopted by the Procurement Policy Board. This is a measure that has been debated for some time now over the years. And we will learn more about from our testimony. First up, we have testimony with comments from the Department of Accounting and General Services.
Thank you, Chair, Vice Chair, and members. I'm Gordon Wood, appearing for the department, which stands on its written testimony, and I'll be available for any questions you may have.
Could you briefly summarize your testimony, sir?
Yes, it does require a bit of a close read. Our testimony is in support of the testimony of the State Procurement Office, which opposes the measure.
Try that again.
We support the State Procurement Office in its opposition to the measure.
Okay. Okay, thank you.
Thank you.
Carrie Ann Sasake? Let's see, testimony from Tim Lyons. Subcontractors Association of Hawaii.
Thank you, Chairman, members of the committee. As noted, I'm Tim Lyons with the Subcontractors Association. And this is an extremely sensitive area that has to do with the financial health of subcontractors. It's been around for a while, as has been noted. Both sides are pretty set in their ways at this point. However, this bill does tend to work towards a solution of what the general contractors say is an insufficient amount of time to put their bids together. Although we don't necessarily subscribe to that theory, we do understand that the parameters of this bill that are specified and in the spirit of cooperation, we're willing to go along with it. However, we would like to request that the sunset clause at the end of the bill be amended from 5 years to 2 or 3 years, because if this turns out to be a disaster, as we are fearful that it may be, we would hope that disaster is short-lived. Thank you.
Thank you very much. I want to go back to Carrie Ann Sasake, who's on Zoom, and offer the opportunity to testify. Please proceed.
Hi, good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee. My name is Carrie Ann Sasaki, testifying on behalf of State Procurement Office Acting Administrator Bonnie Kahakui. The State Procurement Office stands on its written testimony, and we're here for any comments or questions.
Thank you. If I could ask you to briefly summarize your testimony in a way we'd understand.
Well, we just feel that the bill is not necessary, as mistakes are already addressed in statute and rules. It does address like missing signatures or typographical errors, and further, additionally, the procurement officer may correct or waive obvious mistakes that, if allowed to be corrected or waived, is in the best interest of the purchasing agency, and if it's fair to the other bidders. So therefore, we don't think it's necessary. We do feel that that it's the responsibility of the contractors and subcontractors to submit clear and correct bids as much as possible by the deadline. So we don't what is that? We're not for opening the bid 24 hours after the bid deadline.
Okay. Thank you very much.
Thank you.
Next, we have testimony and support from the General Contractors Association of Hawaii. Mr. Sakuda, welcome. The floor is yours. Please proceed.
Good afternoon, Chair, members of the committee. So the purpose of this bill is to attempt to reduce the number of bid protests regarding subcontractor listing. One agency described the scene at bid opening as general contractors will examine the subcontractor listing of bidders who submitted lower price bids, and they'll photograph those listings. They'll then go to the professional and vocational listing website, check the licensing information of those subs with the hope of finding technical flaws to protest on. So we're hoping that this measure will address some of these issues. The GCA and Subcontractors Association, who previously just testified, have finally compromised on a model that has the potential to reduce these protests. So what we did is we looked at California's procurement code as a model, and this is what they've implemented. This is also a recommendation that was given to the State Procurement Office by an independent study. So for these reasons, we hope that the committee moves this measure to allow the parties to continue discussion to help address this long-standing sublist issue. Thank you.
Thank you very much. Next, we have testimony in opposition from Jeffrey Masatsugu. Welcome. The floor is yours. Please proceed.
Thank you, Chair, and good afternoon, Vice Chair also and members. My name is Jeff Masatsugu, and I represent 4 labor management cooperation funds. These are jointly administered funds by the union and their signatory contractors, and those funds are for the painters, drywall tapers, glazers, and carpet and soft tile layers. Chair, we're in opposition to this measure. We have our written testimony. I want to highlight two parts of our written testimony. The first is that this is not the significant problem it is being made out to be. And you heard a reference to an ECOSCO report from the GCA just now. That report was submitted to the legislature through the SPO in January of 2020.
It's the State Procurement Office.
State Procurement Office.
I'm trying to avoid using jargon or acronyms, just so everyone understands what everyone says. So please proceed.
Yes, thank you, Chair. So this report that was referenced by GCA reached out to all of the stakeholders, including the GCA, and it examined a number of issues, which included the correction and modification of mistakes in bids. And I referenced the section of the ICASCO report that discusses this. And ICASCO noted in its report that none of the people it contacted thought that there was a problem with the correction or modification of bids in this process. So it's disingenuous to now say that there's a problem when the report came out as of early 2020, there was no indication of any problem. The second thing I want to point out is how this bill is going to work. As a practical matter, although this bill prohibits bid shopping, it's going to open the door to bid shopping because of the 24 hours that are allowed before the opening of bids. And this is the key part to understand, before the opening of bids, because that's when the bid shopping happens. The general contractor loses all of their leverage to bid shop the subcontractors once the bids are open and the procurement officer can see who is listed as a subcontractor. And I want to, in connection with this, I want to reference GCA's testimony.
If you could summarize, that'd be great.
May I address GCA's testimony about California law, because I think it's a critical point. It's very misleading. You know, if you look at California law allows corrections and modifications to a bid after the opening, not before. And again, and for the reasons that I explained to you, why that is so. I just want to leave you all with this thought. What are we doing here? This is going to punish the general contractors that have done their homework and that have submitted bids without problems. All the general contractors who have done their homework and made sure the subs they've listed are qualified and responsible, those are the ones that are going to be punished. What we're going to be doing is actually lowering the standards for procurement of construction in this state. Something we should not be doing, and so we're strongly opposed to this. We ask you to defer this measure. Thank you.
Thank you very much. Thanks for adjusting the microphone. We just want to make sure everyone can be heard. Great. Thanks, Keone. Next up, we have Candace Ito from the Contractors License Board. Welcome. Please proceed.
Hello, Chair, Vice Chair, and members of the committee. I'm Candace Ito. I'm the Executive Officer for the Contractors License Board, and the board submits comments. And to summarize our testimony, the board has serious concern that this bill authorizes unlicensed activity from the time the bid is submitted to the time the contract is awarded, which is a violation of Chapter 444, which is the contractor license law. And I'm sorry, I had amended testimony because I found an error in my testimony, so I apologize.
That's
for
fine. I appreciate your diligence, making sure that we get the correct testimony.
Okay, thank you.
Thank you very much. Next, we have testimony and support from Danny Kupchoy with HOEISF PAC. And then, which is the Hawaii Operating Engineers Industry Stabilization Fund, PAC, Political Action Committee. And then finally, we have testimony in opposition from Gino Sekena, Hawaii Building and Construction Trades Council. Welcome, please proceed.
Good afternoon, Chair Tarnis, Vice Chair Takayama, and members of the committee. My name is Gino Sekena. I'm the Executive Director, and Chair Tarnis, you said it right, so Kenya is the right way to say it, my last name, but you're very close. I'm the Executive Director of the Hawaii Building and Construction Trades Council. I represent 18 of the 19 construction trade unions here in Hawaii. We are in opposition to this bill. We feel that it's not needed. HRS Chapter 103D and the administrative rules already allow for these changes, and we just don't want to see any, open the door for any problems in the future. So thank you for the opportunity to testify.
Certainly. Thank you for testifying, Mr. Soquena. Is there anyone else here wishing to testify on HB 542? If not, questions, members? Any questions? No, I think I appreciate having the testimony in advance. It's very helpful because this is a complicated matter. And you've been at this for a while. This dispute's been going on for a while. Okay, if there's no questions, we'll move on to the next measure. Last measure for testimony today, House Bill 572 relating to administrative rulemaking requires that prior to the adoption, amendment, or repeal of an administrative rule, that electronic notice of the proposed rulemaking be provided to all persons who have made a timely written request to and provided a valid working email address to the adopting agency for advance notice of its rulemaking proceedings. And it requires that all alterations to administrative rules be displayed in Ramsire format and the full text of the rules be made available in a digitally accessible and searchable format. Ramsire format is where you bracket and cross out the parts of the rule that are being omitted and the parts that are being added are underlined. We use it at the legislature. It's very useful because then you can look at it and understand what's been changed. So that's what this bill will do for any changes in the rules. House Bill 572, we have testimony in support from the Office of Lieutenant Governor. Next, we have testimony support from the League of Women Voters of Hawaii. And testimony in support from the State of Hawaii Organization of Police Officers. And testimony in support from Dana Keawe. Is there anyone else here wishing to testify on House Bill 572? Seeing none, any questions, members? Nope. Okay, thank you. Have I covered everything? Did I? Nope, oh, that's it. Okay, is there any, if there's no more questions, if there are no questions, and that is the last measure on our agenda for testimony, I think we can go into decision-making. Lieutenant Governor's Office here. I was just wrapping up. If you would like to testify on House Bill 572, this is your chance.
Okay, thank you, Chair.
Your timing is impeccable. Well, it's about 30 seconds off, but pretty close.
Thank you, Chair and Vice Chair, members of the committee. Riley Fujisaki on behalf of the Office of Lieutenant Governor. We're just here to stand on our written testimony providing comments on the bill. Thank you.
Well, since you came all the way here from the, all the way downstairs, could you give us a summary of your testimony, so rather than just standing on it?
Yes.
Why is this bill important?
So the process of combining the admin rules so that they're accessible to the public is an important part of the Lieutenant Governor's plans for her office. We did want to note that there might be some additional resources that might be needed in order to fulfill this, the purposes of this measure.
You're asking for one FTE position and funding to build and maintain the new website components.
Yes, that's correct.
So that's the additional resources.
Yes, yeah.
That you're talking about.
Yeah,
Just want to make sure everyone understands. Okay, thank you very much.
Okay, thank you, Chair.
Is there anyone else here wishing to testify on House Bill 572? If not, questions, members? Yes, Representative Ganadin, please proceed.
Thank you. To the Office of the Lieutenant Governor, do you really need an FTE position? This sounds like a simple change in a Word doc in the way we use it.
I think part of it is trying to re-envision what would be available on the website itself, whether it would start simply as a website that combined PDFs, but then eventually move to something that we have like with the HRS system, where it's fully searchable, all online, and then in HTML format as opposed to just being a static PDF.
Can we just link to the new legislative website, if that's the case, and the various departments' websites?
We could, but right now, as it's being stored, each department is responsible for posting their own admin rules, and they're all posted in a slightly different fashion. And right now, the majority of them are all still in PDF format.
Okay, thank you.
Thank you very much. Any other questions, members? If not, thanks very much. Appreciate you being here. All testifiers for being here on all these measures. And we're going to go into decision-making. And what I'd like to do first for the members here, I wanted to talk about House Bill 1404, which we had deferred to today for decision-making in hopes that the three entities that work together on the Community Court Outreach Project would be able to work out a consensus on the language, and that would be the public defenders, the judiciary, and the prosecuting attorneys. They tried. And I acknowledge that you worked at it and weren't able to come to a consensus, but you're still willing to work together, and my encouragement is to please work together. I'm happy to work with you, and that we can come back with some consensus measure in the future, because this is an important community court outreach project. Is a very important project, and we want to support it going forward. But I want all three of you to be on the same page. So thanks for trying. Well, let's keep working on it together, okay? So members, we're going to defer House Bill 1404 at this time and encourage the parties to work together, the stakeholders to work together, so we can come back with something solid. So thank you very much to the judiciary and to the prosecutors and the public defenders. Okay, let's go back up to the top of the agenda, members, to House Bill 340. Relating to Brother Joseph Dutton Day. I would like to recommend we move out an amended bill, so there'd be a House Draft 2. And I know from members that there is an amended testimony from the Joseph Dutton Guild. So the amended testimony says, don't worry about Brother Dutton title. Even though he was a layman, everyone called him Brother Dutton. So they had initially asked that we remove the word brother. But on second thought, and after talking to folks, they said, no, let's not do that. Keep brother, the word brother in there. Since we all refer to him as Brother Joseph. But they do have a recommended amendment, which is, rather than say that Brother Dutton suffered from post-traumatic stress disorder, they would like us to revise it so the sentence reads, following the Civil War, Ira Barnes Dutton suffered from a failed marriage, alcoholism, probable post-traumatic stress disorder, and other personal problems, leading him on a journey to seek atonement through Catholicism. So we're changing post-traumatic stress disorder to more accurate description. And I will defer to the Joseph Dutton Guild on the details, so that my recommendation is to adopt their recommended amendment and moved out an HD2. Questions or concerns, members? I got the okay from all the members here to move forward. So Vice Chair for the vote.
Voting on House Bill 340 HD1 with further amendments, Chair and Vice Chair vote aye. Representative Ganadin. Aye. Representative Holt. Aye. Representative Hashimoto. Aye. Representative Ichiyama.
Aye.
Representative Ilagan.
Aye.
Representative Kong.
Aye.
Representative Mizuno.
Aye.
Representative Souza.
Aye.
Chair, your recommendation is adopted.
Thank you very much. Next, let's move on to House Bill 105. I would like to move out an amended bill, so that'd be House Draft 2, just making some technical amendments for clarity, consistency, and style. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 105 HD1 with further amendments, noting the presence of all members. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. Moving on to House Bill 739, relating to motor vehicle safety inspections. On this one, I would like to amend the bill, so we would have a House Draft 2. I would like to amend the bill as suggested by the City and County of Honolulu, it's in their testimony. Basically amending the bill so that the bill will be limited to only those situations where both the motor vehicle's registration and safety check are expired, and that the owner of the motor vehicle will be allowed to first register the vehicle without a safety inspection certificate, and then upon the registration of the vehicle, a safety inspection certificate may be obtained. So that's my recommendation, to include that amendment. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 739 HD1 with further amendments, noting the presence of all members. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. House Bill 365, everyone seems very comfortable with the language on this, and I'm happy with it, so I would like to move it out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 365 HD1 passing as is, noting the presence of all members. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. Next bill, House Bill 792, relating to minors. On this one, I'd like to move out a House Draft 1. And my only suggestion is this one amendment from the public defenders. It's on the second page of their testimony, to replace the term minor with the following. It would be, quote, minor or adult convicted of a felony offense that was committed prior to reaching the age of majority, end quote. So every time the word minor comes up in the bill, we would use that phrase. And this way, we can make sure that this, if we don't do that, then this bill would not apply to a person who committed the crime prior to reaching the age of 18, but was convicted when they were over 18, or 18 or older. So this would make it clear. So that's my recommendation. I'd like to leave the effective date clean and move it through with that amendment as an HD1. Questions or concerns, members? Representative Gannon.
Just want to share my appreciation to the introducer, all those who testified out there on internet land. I think this is one of many measures that we're introducing this year to treat kids like kids and fix a justice system that has been inequitably applied on certain communities. Thank you so much.
Thank you. I appreciate you speaking from experience. That really helps this committee. Any other questions or concerns? If not, Vice Chair for the vote.
Voting on House Bill 792 with amendments. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. House Bill 781. On this one, I'd like to amend the bill, so it would be a House Draft 2. I would like to, I note that the word guardian and legal guardian are both used in the bill. And what I'd like to do is use the word guardian, and because I think it has broader applications. So we would call it guardian throughout. And in addition, on page 3, it uses the term legal custodian. And so what I'd like to do is on page 3, line 1 and 7, and on page 16 and 17, I will replace legal custodian with the phrase parent, guardian, or legal custodian. That way we're clear throughout. So actually, every time where there's the word guardian or legal custodian, let's use the phrase parent, guardian, or legal custodian. So that way we're clear throughout. It already has a defective effective date. So with that change, I'd also like to include in the Standing Committee report that the committee believes that the police departments, the county police departments, will need to change their policies and procedures to implement this measure, and they will need to carry out programs to educate the officers about this program. So we're going to put that into the Standing Committee report. Oh, yes. And the public defender, I'd also like to adopt the public defender's recommendation. They had concerns about Section 2, subsection D in their testimony from the public defenders. And their recommendation I'd like to adopt, so it would be on page 3 of the bill at the bottom, subsection D, all the way to the next page, 4, subparagraphs 1 and 2. So I'd like to delete those sections of the bill as recommended by the public defender. So those are my recommendation on this measure. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on HB 781 HD1 with further amendments. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you very much. Next, relating to family, House Bill 618. Everyone seems happy with this bill. I'm happy with the language in this bill. Let's keep being happy and move it out as is. Recommendation, or that's my recommendation. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 618 passing as is. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you very much. House Bill 1045 relating to education. I think everyone is satisfied with the language of the bill. It currently has a defective effective date, which we'll keep in there, and I'd like to move this out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1045 HD1 passing as is. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. Moving on to House Bill 1057. I have to listen to Mrs. Kapuniai. So I'm going to defer the bill. If those who weren't here during questioning, the Department of Hawaiian Homelands explained why they felt this was necessary. They still would carry out beneficiary consultation, but Mrs. Kapuniai, who submitted testimony on this, is a good friend and kupuna from my community, and she's not convinced, so I really can't move this forward. I got to listen to her. So we're going to defer this measure, and I would encourage the Department of Hawaiian Homelands to keep working on it. Okay? Thank you. Moving on to the next measure, House Bill 542. I recognize that this has been a long-standing conflict. I recognize that those folks, testifiers who came in opposing this bill also submitted testimony to the Labor and Government Operations Committee. And after considering it, the Labor and Government Operations Committee made the amendments to the bill and moved it out. And so I would like to do the same. The one amendment I would like to make to it for House Draft 2 would be to adopt the recommendation from the subcontractors and change the repeal date. Right now it is repealed in 2028. I would have it repealed in 2026. And I do have prior concurrence from the chair of the House Committee on Labor and Government Operations. That's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 542 HD1 with further amendments. Anyone wishing to vote WR or no?
With reservations.
Reservations noted for Representative Kong and Representative Ganadin. Any other WRs or noes? Seeing none, Chair, your recommendation is adopted.
Thank you. Final bill on this agenda, House Bill 572. I would like to move this out as is, but include in the Standing Committee report the recommendation from the Lieutenant Governor's office that this would require one FTE position to oversee the website updates and funding to build and maintain the new website components. We can't put the money or positions into this bill, but we'll put it into the Standing Committee report so that can move on as this bill will continue to be considered. When it if we get approval from the rest of the House, it'll move over to the Senate, and then you can work with them to see if they can actually put some money into it and positions. So we'll leave that at that. That's my recommendation, as is, with those comments in the Standing Committee report. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 5782 HD1 passing as is. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. Thanks for everyone for being here today. I appreciate all the testifiers and all the members for being here. We will be having a hearing again tomorrow, so I look forward to seeing you then. There's no further business before us today. This meeting is adjourned.